Hello viewers, I am Professor Sharanjit from the Rajiv Gandhi National University of Law. Today we shall be talking about the liability of the employer and the limitations on the liability of the employer. Under the law of torts, it is a very well recognized fact that ordinarily a person is liable for his own acts and omissions only and not for the acts or omissions of others. However, there are circumstances where a person may be held responsible for the tort committed by another person. For instance, the liability of the principal for the wrongful acts of his agent, the liability of the states for the torts committed by its employees, the master's liability for the wrongful acts of his servants done in the course of employment, and the liability of a parent or guardian for the wrongful acts committed by the children or the wards. Why should employers be held liable for the wrongful acts of their employees? The basis of this liability can be traced to the legal maxim, "Koi facit per illum, facit per se." This means, he who acts through another does the act himself. Thus, the employer's liability for the acts of his employee or servant is based on this very maxim. Furthermore, the law presumes that the master has given consent and authority to the servant for all acts performed within the scope of their duties and authority, making these acts attributable to the master. The master bears responsibility for the servant's acts, whether rightful or wrongful, if they are within the scope of the servant's authority and duties, even without a specific or express command. Listeners, we will focus on the employer's liability for the torts committed by their employees and the limitations of this liability. For the application of this rule, there must be an employer-employee relationship between the defendant and the wrongdoer. After proving this fact, the court will consider whether the employee committed the alleged act in the course of his or her employment. The courts have devised certain tests to determine the employer-employee relationship. The courts rely on the control test as a primitive test. A person is said to be the employer or servant of another if he works under the control of such another. According to Dr. Winfield, vicarious liability arises from the contract of service but not from a contract for service. A servant is employed under a contract of service, whereas one who is engaged under a contract for service is called as an independent contractor. Listeners, in the later years, a well-known jurist, Freund, came up with the modern organization test. He was of the view that in modern times, the efficacy of the control test has declined due to changed industrial relations, the vastness of the business and commercial world, and the fact that the courts have shifted the emphasis from effective control to possible control. He believed that although the control test is undoubtedly significant, it can no longer be considered the sole determining factor due to the expanding dimensions of trade, commerce, investment, and management, which require performing a large number of tasks. The second aspect in this regard is with regards to the scope of employment. Once the court has ascertained the employer-employee relationship between the master and the wrongdoer, it must determine whether the master should be held vicariously liable or not. The employer can be held liable for the wrongful acts of their employee if the employee performs the act within the scope of their employment. Here it is significant to note that an act will be said to have been done in the scope of employment when firstly the master has authorized the servant to do a wrongful act or the wrongful and unauthorized mode of doing an act authorized by the master. Here it is important to discuss the case of Gyarsi Devi versus Sen Das in the year 1982. In this case, the driver of a truck left the loaded truck in charge of the cleaner and went to take his meals. He directed the cleaner to get the truck unloaded. The claimant suffered injuries from the truck while it was being unloaded. The master was held liable because the driver was entrusted with the duty of unloading the truck, but instead of doing it himself, he assigned it to the cleaner, and therefore it was an authorized work that was done in an improper and unauthorized manner, and therefore the master could not be insulated from the liability. Listeners, in contrast to this case, we can now take up the case of Twine versus Beans Express Limited, 1946. The defendant had two signs on his van, one stating that nobody else was allowed to get a lift in the van, and the other instructing the driver not to let anyone else inside the vehicle. Despite these explicit directives, the van's driver disregarded them and gave a lift to an unauthorized individual who died in an accident caused by the driver's carelessness. The master did not face accountability for the driver's act of disobedience since it fell outside the scope of the employment. It is important to note that an employee, in cases of necessity, is also considered to be acting in the course of employment if he is performing his employer's business. Now we shall talk about the main incidents of the master or the employer's liability. They can be enumerated as under. Firstly, the mistake could be the inevitable result of anything the servant did with the typical caution while carrying out the master's explicit instructions. Second, if his servants are careless, the master will be held accountable. Thirdly, the servants may be wrong due to acting in excess of the authority but mistakenly believing it to be the lawful authority. Here two requirements must be met. First, it must be demonstrated that the servant meant to act on his master's behalf when in fact he was authorized to do so, and second, it must be demonstrated that the act would have been legal had it been carried out correctly. Next, intentional wrong actions are still carried out for the benefit of the master and to further his goals. Fifth, the false act of the servant may have caused the error. Sixth, an illegal act by a servant may have caused the error. Dear listeners, moving on further, now we shall study the wrongful act done by a servant for the master's benefits. There may arise situations where the servant is placed in a situation where he does an act that, though not authorized by the master, needs to be done for the master's benefit. In such cases, the master is generally held liable for the injury or harm caused by the wrongful act of a servant. In the case of Bailey versus Manchester Sheffield and Lancashire Company, the railway porter pulled out a passenger from the train on which she was boarding, thinking she had boarded the wrong destination train. It was one of the duties of the porter to see that the passengers got into the correct or proper train. Therefore, it was only a mistake in doing an act entrusted to him and not an altogether unauthorized act. Hence, the railway company was held vicariously liable for the wrongful act of its porter. Another case in this regard is Anita Bhandari and others versus Union of India, 2004. In this case, the bank guard mistakenly believed that the dead person, who was actually a customer, had come to the bank to commit a dacoity. As a result, the guard shot the man, killing him. The court determined that the guard's actions were within the course of his employment, resulting in the bank being ruled vicariously liable for paying the deceased person's dependents compensation. Contrary to popular belief, the master will not be held liable for the servant's deliberate wrongful acts motivated by selfish interests, benefits, or ulterior motives. An interesting case is that of State Bank of India versus Shama Devi of the year 1978. In this case, the respondent, a lady, gave some money to be deposited in the State Bank of India to her neighbor who was employed as a clerk in that branch of the bank. The said clerk made an entry for the deposit of the money in her passbook, but instead of depositing it, she misappropriated it. When the respondent learned about the non-deposit of the said amount to her credit, she sued the bank. The bank claimed no liability for the misappropriation committed by its employee. It was held that the respondent had given the money to her neighbor on her own accord, as the neighbor was an employee of the bank, and therefore she was herself responsible for this tortious act and not the bank. The appeal of the bank was therefore allowed, and the respondent's claim was dismissed by the court. Listeners, in the next part, we will focus on situations where employees commit certain aggressive actions, including assault, during the course of employment, claiming that it was done to protect their employer's interests. However, it is important to see whether the assault was necessary or not. In the case of Dyer versus Munde, 1895, the defendant, a furniture dealer, sent his messenger to retake an article of furniture from the customer who had hired it under a hire purchase agreement and had defaulted in the payment of the installments. The court held the defendant liable for assault when his messenger forcibly removed the landlady from the chair in which the hired article was kept. The defendant had authorized the messenger to remove any obstruction that came in the way of retaking the furniture. Moving on, in the case of State of MP versus Shanti Bai and another, 2005, the police opened fire on a mob to disperse it, knowing well that many people were watching the clash from the roofs and firing may cause injury to them. The state was held vicariously liable for the injury caused by the bullet, the reason being that their act of firing was unauthorized and was done in the course of employment, even though it was done in an improper manner. Listeners, next we shall discuss the doctrine of common employment. The doctrine states that a master is not responsible for negligent harm caused by one of their servants to another servant due to the existence of a common employment between them. This doctrine was first involved in the historic judgment of Priestley versus Fowler, 1837. The plaintiff, who was a servant of the defendant, suffered injuries when an overloaded carriage driven by another defendant servant broke down and caused him a fracture in his leg. In this matter, the court held, keeping in view the theory of common employment, the wrongdoer and the injured party could claim compensation from the master for the harm that one of them had caused to the other because they were both the servants of the same master. Similarly, in the case of Johnson versus Lindsay, 1891, where harm was inflicted by one servant on a fellow servant of the same master, the master was not liable because the servant was presumed to have agreed to run the risk incidental to his employment, including that of his fellow servant's negligence or incompetence, which might result in damage or harm to him. Listeners, it is significant to note that the doctrine of common employment was never formally recognized in the Indian context. In the case of Secretary of State versus Rukmini Bai, 1937, a gangman working on a railway track was run over and killed by the negligence of the railway driver. The then GIP Railway Company invoked the doctrine of common employment, but the court rejected the plea and held that it was not expedient to apply the principle of common employment to provide protection to the employer against the consequences of wrongful acts of their servants in the prevailing Indian conditions. A question may often arise in our minds about whether the employer is responsible for the acts of an independent contractor or not. In this regard, it is important to note that an independent contractor employed for a particular work employs his own workers, raw materials, and skilled persons to carry out the project and complete the work assigned to him within the stipulated time period. Therefore, it is felt that while carrying out the work, he is not subordinate to the person who has given him the contract, except that he has to satisfy the requirements of the contract. From this, we can infer that an independent contractor is free to make his own decisions while carrying out the work without any interference from the employer, and it is for this reason that it is generally said that a contract by an independent contractor with the employer is a contract for service and not a contract of service. In the case of Morgan versus Incorporated Central Railway Council, 1936, the respondent company had assigned the work of looking after the functioning of the lift to an independent contractor. One day, the door of the lift suddenly opened due to a defect, throwing the person inside out and causing serious injuries to him. The injured sued the company for damages. The court held that the company was not liable since it had employed an independent contractor to oversee the operation of the lift. The court observed that the plaintiff should have sued the independent contractor for damages instead of the company that engaged the contractor for the lift service. Thus, we have to differentiate between a servant and an independent contractor. An employee is an agent who works under the supervision and direction of his employer, whereas an independent contractor is one who is his own master and has to work only as per the terms of the contract. Furthermore, a servant or employee has to obey the employer's directions from time to time. On the other hand, an independent contractor engages in specific work while exercising their own discretion regarding the mode and other technicalities. This suggests that an employer who hires an independent contractor under a contract of service is generally not liable for the contractor's wrongdoings. However, there are a few instances in which this rule may not apply, including when the employer interferes with the contractor's work and causes harm to an individual or individuals. Similarly, when the work assigned to the contractor is unlawful or is in violation of the law, or when the contractor engages in conduct that is subject to the absolute liability rule, the liability can be fastened on the employer as well. Alternatively, the employer would be held accountable for the independent contractor's negligence in cases where a law imposes an absolute duty on him to use caution and diligence. Where the employer has failed to employ a skilled and competent contractor for his work, he would be personally liable for negligence in selecting the proper contractor and the consequences of the same. A question often arises about whether the employer can be held liable for the criminal acts committed by its employee. The Supreme Court of India, in the case of Shyam Sundar and others versus State of Haryana, 1989, has held that the principles of vicarious liability have no application in criminal law unless the statute also takes them into its fold. In the end, we can conclude by saying that every person is presumed to know the nature and consequences of his or her act and is made responsible for the same. However, when an employee commits a tort in the course of performing his duty towards the employer, the liability of the employer arises from such a wrongful act. The employer is made liable as there is an employee-employer relationship between the two and the employee is working on behalf of his employer. Both may also be held accountable for the same offence or negligence. Their liability is joint and multiple, and they may be regarded as joint tortfeasors. It is important to remember that a servant's actions are considered to be outside the scope of their employment when they are not related to the master's business. It is evident that the wrongdoing by the servant would be outside the scope of employment when it was not committed in the regular course of his master's business. Merely because the servant would not have had the chance to do the incorrect thing if they were not employed by the master, the act in question will not be considered to have occurred during the course of employment. To conclude, I would like to quote the case of Beard versus London General Omnibus Company, 1900. In this case, the bus driver went to eat dinner at the conclusion of the trip. When the driver was temporarily away, the conductor drove the bus to turn it around and prepare it for the next trip. This resulted in an accident that harmed the plaintiff due to the conductor's negligence. The driving of the bus was not the conductor's responsibility. Accordingly, the defendant corporation was deemed not liable since the conductor was not working in the course of his employment and the driving was not the kind of act that he was authorized to do. With this, we come to an end of this session. Thank you.